Hello family, this is Zebra Family Channel. I want us to look at these two pictures, these videos of accused 1 to 5 in the sense of Meyiwa case, and accused, I can't remember how many they are in the AKA case. Then you will listen to my conclusion at the end, and you will hear from the lawyer how lawyers feel when their client come in court in leg iron chains and in handcuff. So let's listen.
My lord, the first application, I believe that's the application that you should hear separately, pertains to the fact that accused number 1, 2, 3, and 5, and I shall colloquially just refer to them as the 4 accused with exclusion of accused number 4, are currently before the court, and their movements are restricted by virtue of the fact that they have to wear leg irons. I have raised this issue with my learned colleague on behalf of the state in the presence of the persons in command of the security detail relating to this matter, and I was informed that we cannot reach an agreement regarding the removal of these irons.
Kanti-ke baninzana ngaphambi kwenkantolo umnqobi kamali oqala wesibili nowesithathu nowesine isikhalo sakhe ngaphambi kokuba-ke achubeke ngaphambi kwenkantolo namhlanje uthula-ke ngaphambi kwenkantolo ukuthi unenkinga yokuthi-ke anikhoni ukuhamba kahle ngoba niboshwe iy'nyawo ngensimbi,
and that I should therefore approach the court to make a ruling in this regard. Now, my lord, having regard to what I've said previously, I wish to refer you very briefly
uthi-ke uyacela ngaphambi kwenkantolo ukuthi-ke mawuphumulwe-ke lamalanga yasey'nyaweni futhi uzothanda ukubhekisa enkantolo emacaleni athile
to matters of a like nature and what has transpired in previous decisions. And the first two decisions that I wish to bring to your attention are indeed decisions that were given long before we had a constitution that currently governs the right of an accused of a fair trial.
kanti-ke uphawula-ke ngamalungelo-ke womuntu-ke ongumangalelwa ome ngaphambi kwenkantolo ukuthi-ke unelungelo lokuthi-ke icala lakhe-ke liculwe kahle-ke ngendlela elungile noma-ke ngobulungiswa. Kanti-ke lokhu-ke ukuphawula-ke emacaleni akudala ngaphambi kokuba-ke kuqale ukusetshenziswa-ke i-constitution esetshenziswayo.
We would submit at the later stage, my lord, that the refusal to remove these shackles has got far-reaching consequences.
Kanti-ke uthi-ke ummeli yena-ke uzokhuluma-ke noma-ke uzolwela ukuthi-ke uma-ke amahangaphoyi lawa angakhululwa lokho-ke inkantolo izobe ingasebenzisanga ubulungiswa.
Well, the first case that I refer you to is the matter of State versus Stevens. It's a provincial division decision handed down by the Mont J, and it's reported in the South African Law Reports 1961 in the 3rd volume on pages 518 and 519.
Icala-ke lokuqala ozophawula kulo-ke icala lika-Stevens elake laba khona kuyo yona le nkantolo, kanti-ke laliphethwe-ke laba khona ngo-1961 ngaphambi-ke kuka-Judicial.
And I would take the liberty to read from paragraph H on page 518, where the learned judge stated the following: after the prosecution had closed its case this morning, counsel for the defense called the accused as a first witness. If I may interrupt myself, he was standing accused of murder in that matter. When the accused left the dock, I became aware that he was in leg irons. I immediately adjourned the case. My reason for so doing is because I object to accused man being brought into court in chains and leg irons. When he is brought into court manacled, one draws the inference that he is a man of bad character in that it's either dangerous to allow him loose, or alternatively, that he is a man who has escaped from custody before. Either way, there is a possibility that he may be prejudiced. In the circumstances, I adjourn the court for further information. I have since been informed by Mr. Brunet, the Attorney General's assistant who is prosecuting in the matter, that he was not consulted in advance by the prison authorities. It differs from our case. The state has indeed been consulted by the security detail and the prison authorities. Indeed, he was not even aware that the accused was in leg irons until he walked to the witness box. I'm also informed that the manacles cannot be removed as the keys are not here, but that they are kept at the prison. He then continues stating, I think the whole position is unsatisfactory. I have previously said that I do not wish to see people in the witness box in my court in chains, and that it is a matter for me to decide and not for the prison authorities. In any event, it seems to me that the prison authorities should consult in advance with the Attorney General, which has been done in this case, in a case where they feel it's necessary to have a man in chains. I think that if it is felt that the accused is a dangerous person and that he may attack the judge or try to escape, then extra police protection can be provided in court. Such cases must be rare. If I may stop there, my lord, I don't know if you have counted the security detail in this court. I think no less than 23 at the last count. And they are armed to the teeth. And this is inside the court. Outside the court, you can take it from me as an officer of the court, there are other officials.
Kanti-ke kafushane ngikulethala-ke kwaphawula ukuthi-ke ujaji wathi-ke uma ebona
Judge then
ulimala.
continues, and he says, I have decided in the circumstances that it will be wrong for me to continue in this case, and I have therefore come to the conclusion that I must recuse myself. That is then what he said 54 years ago.
Kanti-ke lecala-ke uma-ke sesibala lineminyaka eyi-54 laculwa, kanti-ke ijaji lapho kafushane yaphawula ngokuthi-ke yathi-ke uma ibona umala lwasekeya
To refer to you prior to the
witness box.
Constitution coming into place. It's the matter of state versus Pakis.
Pakis.
Pakis, P-A-K-K-I-E-S.
Yes.
It's a decision in the Transkei Division, Supreme Court.
Right.
Pickering A.J. It's reported in the South African Law Reports, 1985, the fourth volume, on page 592. There is a short summary, and then on page 593, the judge then states the following from paragraph B. The accused in this case is charged with murder. Before the case was called this afternoon, it inadvertently came to my knowledge that the accused had been brought to court in chains and leg irons for consultation with his counsel. I may add that neither Mr. Bump for the accused nor Mr. Barnhorst for the state were responsible for bringing this to my attention. I accordingly informed counsel that for the reasons set out in State v. Stevens, the case that I refer to you now, with which I am in respectful and full agreement, it would be wrong for me to hear the case. Both counsel are in agreement that in the circumstances the case should be postponed for hearing before another court. Then the judge continues, not only for accused to be in leg irons before the court, but to be restricted in their movement when they consult with their legal representative, which is in casu the case that we have here. Continues against paragraph D. Before doing so, there is another matter which I must deal with, and that is one is raised by Mr. Bum. He informs me that he requested the prison warders who accompanied the accused to remove the chains and leg irons from the accused in order to enable him to consult with the accused in a free and relaxed atmosphere. They refused to do so. The issue was then referred to certain higher authorities in the Department of Prisons, but Mr. Bum's request was again met with a refusal. Mr. Bum stated that in the circumstances he would not, as a matter of principle, consult with the accused until such time as the chains and leg irons were removed. The judge then continues, in my view, Mr. Bum's attitude is a very proper and correct one. An accused person should be able to consult with his legal advisors free of any constrictions upon his person and in an atmosphere which enable both his legal advisor and himself to speak freely. Justice cannot otherwise be done. I reiterate, this was said in 1985.
Kanti-ke mabili-ke lamacala licala lela lo-Stevens leli-ke elikapakis kanti-ke omabili lamacala akhuluma into yodwa ecishe ifane ukuthi-ke manje la angadluli ngaphambi kwenkantolo aboshwe iy'nyawo nezandla kanti-ke leli elesibili livumelana nalela lokuqala ukuthi-ke inkosi enkantolo yathi mayibona ukuthi-ke umangalelwa wayeboshwe iy'nyawo uma-ke sekazofakaza yase-ke iyazikhulula-ke ecaleni.
My Lord, but in 2005, after the Constitution came into being, another judgment was handed down by Van der Westers and J as he then was in the Transvaal Provincial Division as he then was, the matter of State versus Piri.
P-H-I-R-I.
P-H-I-R-I.
Thank you.
Now, this matter is unreported. It is case number 203305 of the South African Gauteng Province High Court, and it was delivered on 4 April 2005. Briefly, the background in this matter was that an accused was charged being in possession and theft of corrugated iron plates. He was brought to the magistrate whilst he was in leg irons. The magistrate asked him if he does have any objections thereto. He confirmed that he did not have any objections, which in this case, we most definitely have objections thereto. He then proceeded with the case, but then having regard to the two judgments that I have read to you now, he then decided to send the matter on special review, and the court had a couple of things to say regarding these aspects. And firstly, I wish to quote what he stated in paragraph 4 of the judgment of Van der Westers, the Station J as he then was. Section 35(3) of the Constitution of the Republic of South Africa, the Constitution, states that every accused person has a right to a fair trial. It mentions 15 aspects of a fair trial, which are included in the right. One is the presumption of innocence in Section 35, sub 3, sub H. However, the right is broader than the list of specific rights set out in the subsection, and embraces a concept of substantive fairness which is not to be equated with what might have passed muster in our criminal courts before the interim constitution came into force. He then refers to the constitutional case of State versus Zuma and others, 1995, South African Constitutional Court, page 1.
Just a second.
Reported in the law reports.
Could you repeat the citation?
This one is 1995. South African Constitutional Court, page 1. Also reported in the SALR 1995-2, SA 642.
Yes, I'm it. 1995, 2 years.
SA 642,
Yeah.
CC.
Okay.
And in the Butterworth's reports, it's reported under 1995, the fourth volume, BCLR 401. Then continues, the constitutional recognition of the fair right to a fair trial requires criminal trials to be conducted in accordance with the notions of basic fairness and justice. And courts during criminal trials or appeals have to give content to these notions. He then again refers to the Zuma matter, and he further refers to Sanderson versus Attorney General, Eastern Cape, reported in 1998, the second volume, South African Law Reports, page 38, the Constitutional Court decision. And he quotes, and he states that in that case, the need to conduct criminal trials in accordance with open-ended notions of basic fairness and justice.
Which paragraph are you referring to?
I'm still at paragraph 4 from the Westhuizen's judgment,
Okay, fine.
but I'm just reading what he states from Sanderson's judgment.
Okay, fine. That's okay. Thank you.
Says the need to conduct criminal trials in accordance with the open-ended notions of basic fairness and justice and the presumption of innocence were mentioned. In considering what lies at the heart of a fair trial, one should bear in mind that dignity, freedom, and equality are the fundamental values of our Constitution. He then refers to the matter of State versus Tusukuda and others, and State versus Chilu, both reported and combined in a Constitutional Court Judgment 2000, Volume 4, South African Law Reports 1078 Constitutional Court Decision.
Did you say 107?
1078, my lord. He then continues in his judgment to deal regarding irregularities and reviews, but it's not applicable for purposes of this application. So I wish to refer you to what he stated in paragraph 10 of the judgment that I'm currently reading to yourself. If I can just go back one paragraph, in paragraph 9 of the judgment, he basically reiterates what was stated in Stevens as I've presented to your lordship at the beginning of my argument. And he then says, having regard to what the magistrate said, to what Judge Dimon said in that judgment, where he says, I've decided in circumstances that it will be wrong for me to continue in this case. And I may add that my assessors, both of whom are magistrates of long experience, agree with me in the decision that I have come to, and I hope that the prison authorities will consult now with the police and with the Attorney General so that this situation will not arise again in the future. Then Judge van der Westhuizen says, this view was echoed in State versus Pakis, which I've referred to you, and then also in S versus Papiana, 1986, second volume of the Prentice Wall decisions, under paragraph H, 115 and appellate division, the appellant appeared at his trial in prison clothes and with his feet shackled in leg irons. The appellate division compared this information with evidence which should be excluded on the ground that relevance is too tenuous to compensate with its prejudicial nature. He then continues to state in S versus Matembu and others, 1988, first volume, SA, page 145 in the appellate division, Smallberger JA, stated the following against page 155, paragraphs G to H. The practice of allowing an accused person to appear in court in prison garb is undesirable and to be deprecated. I trust that responsible authorities will heed this and similar comments that have been made in the past and act accordingly. The only instance where the appearance of an accused in prison garb may be justified is where his trials involves an offence committed in prison or one related to imprisonment, example, escaping from custody. This is in casu not the case. My lord, what we have is we have 4 accused brought before you in leg irons. And may I pause that I note that accused number 3 when he was brought up, did not have leg irons on, for one or other reason.
When was it?
When he was brought up this morning.
This morning.
Yes. Lord, the Honourable Judge then continues to deal with certain aspects regarding appearance in court, in prison garb, etc., which is not applicable, but on paragraph 15 of this judgment. And please bear in mind, my lord, in this matter, the accused says, I don't have a problem to appear in leg irons. And what the judge then finds at the end. Paragraph 15, and it takes a bit long, but I wish to read it to you to bring it to your attention. Courts have on several occasions expressed a clear view that the practice of accused persons appearing in court in manacles, leg irons, chains, or prison clothing is unsatisfactory, undesirable, and objectionable, and is to be deprecated and strongly disapproved of. On the simplest and perhaps most technical level, it may indicate to a judicial officer that the accused has been brought from prison, where he or she is serving a sentence for a previous conviction, and thus in effect place inadmissible evidence before the court. Under circumstances, it may also influence a judicial officer to draw an inference about an accused character, for example, that he or she is a dangerous person, and a potential threat to the public, court officials, or to the judicial officer. Thus, it may even induce a sense of fear or apprehension. It may also lead to an inference that he or she has escaped from custody before, or has given reason to believe that he or she would escape if the opportunity arises. All of this, to some extent, relates to the presumption of innocence, which is an aspect of the right to a fair trial, as guaranteed in Section 35(3) of the Constitution. However, the undesirability of such a situation goes further. The appearance of an accused in court in leg irons or chains or in prison clothing violates the human dignity of the accused as a person. The recognition of human dignity lies at the heart of the constitutionally guaranteed right to a fair trial, and indeed of the Constitution itself, together with the rights and values such as the right to freedom and security of the person, Sections 10 and 11, Equality, Section 9, and the advancement of human rights and democracy, Section 1. As far as humanly possible, an accused person should be viewed by the court not as a criminal, a dangerous character, or a threat, but as a person whose guilt must be proved beyond reasonable doubt and who has the right to defend him or herself freely within the prescriptions of the law. Ultimately, the dignity of the court is at stake. It is a civilized forum for rational discourse and analysis, and not a detention, punishment, or torture center. The confidence of the public, both from the perspective of the accused, or his or her family and friends, as well as the victims of crime and those close to them, depends on perceptions of the fairness of criminal proceedings. My Lord, we submit that if they continue to appear in such a way before your Lordship, that this will be violated. Lastly, from the judgment, paragraph 18, courts and judicial officers have to be independent and must apply the law impartially and without fear, favour or prejudice. That is sections 34 and 165, sub 2 of the Constitution. Courts are indeed presumed to be impartial. It then refers to the matter of the President of the South African Republic of South Africa and others versus the South African Football Union and others, 1999, volume 4, South African Law Reports, page 147, a Constitutional Court decision. The ability to remain impartial and objective even in the face of potential influences can therefore be expected from judicial officers to a considerable extent. Yes, as is clear from the cases referred to, some judges have in the past not hesitated to recuse themselves when accused persons appear before them in prison clothing or in leg irons. When a judicial officer does not feel comfortable hearing a case because of factors which could affect his or her impartiality or perceived to do so, it is proper to recuse oneself. My Lord, the judge then continues to state that not all irregularities will necessarily result in a reversal of a conviction, etc. But there are circumstances. But we have in this case, unfortunately, a further problem, and that is being compounded. What my learned colleague has mentioned to you yesterday in chambers. And I feel compelled to place it on record that he's indeed informed you that accused number 1 is a convicted prisoner. And I have objected at that stage to that aspect being brought to your attention. We submit that there is no reason whatsoever that accused number 1 to 4 movement should be restricted by leg irons. And then secondly, my Lord, I've submitted these cases and I've indicated that the conduct of the authorities to do so has got far-reaching consequences. And having regard to what is stated, we submit that it is in your Lordship's discretion that your Lordship should evaluate, having regard to the information placed to your disposal, and having regard to the appearance of the four accused and the information placed into your disposal relating to accused number 1, whether you are in a position to proceed with the matter or not. If there's any other aspect relating to this aspect alone, I will gladly address you there.
Kanti afushane umendlala bekecela ngaphambi kwenkantolo ukuthi uyocela ke ukuthi nikhululwe ngokuphawula ke kulawo macala awaphawulila ke bakhona ngaphambi kwenkantolo ngaphambilini.
Mr. Donald. Oh, Mr. Alexander.
Quietly here in the corner, my lord.
Are they yours?
I'm sitting quietly here in the corner, my lord. My lord, prior to my lord entering the court, I was initially discussing the matter with, I believe it's Colonel Oosthuizen. I'm not too sure how the ranks in the Department of Correctional Services work. Colonel, I believe it is Colonel Oosthuizen. Whilst I was discussing with him, he was summoned by my learned friend for the state, and they had a meeting outside to which I wasn't privy to. Colonel Oosthuizen, I believe it's Oosthuizen.
Yeah.
I see the head of the prison from Zonnewater has also made his way to court. Colonel Oosthuizen indicated to me that the head of the prison from Zonnewater would also be at court, possibly just to enter into a discussion. May I impose on the court that we adjourn for a few minutes, that we may discuss the matter to try and resolve the issue? A discussion was held at Zonnewater prison. My lord was made aware of that, where certain agreements, although it seems that there might have been a misunderstanding as what transpired yesterday, what was placed on record, I indicated to my lord what my understanding thereof was. May I request that we adjourn for a few minutes, that we discuss the matter in an attempt to resolve the matter? For taking the matter
few minutes that you are referring to?
5 to 10 minutes. I don't believe it should be long. We'll discuss the matter here in court.
Should I go back to my chambers?
I believe that would be super. I don't believe that my lord should be in the passages.
May I suggest that I see it's almost 5 to 11,
Yeah.
that we adjourn until after the tea break at 11:30. I think they'll give us enough time to sort out whatever issues Mr. Alexander needs to.
It's in.
Family, I want us to look at this today. The 5 accused coming to court on leg irons. Okay, fine. Danzi doesn't have leg irons, and CB, first accused and second accused, they always come up to court with handcuff. They don't have leg irons. But accused number 3, 4, and 5, they have leg irons. Okay, why I want to talk about this, family? I want us to understand something about this, how it influenced the judge to think those people are very dangerous. It's got a big influence to the judge. And most lawyers who understand that, they normally attack this at the beginning of the proceedings of the court. When the case comes to court, they bring it up to the judge. On the very first day, they tell the judge, let's work on this one. It's not going to be fair for the accused, because when you count at the police, armed to their teeth inside court, and outside it's obvious they are armed to the teeth. Why is it that they cannot remove the leg irons? Immediately when the court finishes, they put the leg irons, immediately they go, because there is a cell downstairs whereby they eat their lunch. If they have to eat their breakfast, they eat their breakfast there. Why is it not, when it's time for them to leave the court, immediately the judge adjourn the court? Because immediately the judge adjourn the court, he simply move out. Then they can put the leg irons if they want to be safe or whatever, for whatever reason they put those leg irons under handcuff. But bringing them with that noise, pulling those chains on the ground, and the judge is there sitting, and the judge is thinking, it means these guys are very dangerous. It really influenced the judge's judgment, because the way he sees very dangerous criminals. Why I'm bringing this up? You look at AK, the guys who are suspects that they deleted AK's life. When they come to court, AK was a celeb, as much as Meyiwa was a celeb. But when they bring them in court, If they do have leg irons, they move the leg irons in the cells down. But when they come to the court in front of the judge, they are not handcuffed. They don't have leg irons. That makes it easy. It cannot influence the judge to think otherwise. Though the judge will be reading the charge sheet, but it cannot easily influence him. Like he feel like if these guys can jump from there, they can kill me. It doesn't influence the judge at all. Why I'm bringing up this in the case of these 5 accused on the Senzo Meyiwa case? Because the state has got no case against these people. So they are making all means to put this kind of influence to the judge's mind. That you see how we bring these people here in court. We bring them like this because they are dangerous even to your life. That is the influence that they are perpetuating in court. So that the judge can think otherwise about these people. I don't know what you think, family. Just drop your comment, and because I've put here 2 different courts. The AKA court and the Meyiwa court, whereby it's run by Judge Rata. I'm showing the difference that these are similar cases. These 2 guys were celebs. They were well known in the country and outside the country about their participation in music and in sport. So family, drop your comment respectfully, and let's see how we can take this far. Ngiyathanda nonke ngothando lwalavo ngithi kini ke bantu bakithi. Bravo, bravo, bravo.